Here's the thing, you're one of those people who cannot drink alcohol. But if you don't do that, what's going to end up happening is you may pick up another DWI. You're looking at potentially 6 years in prison if you do on this case, or you may end up driving and killing someone. You understand?
Yes.
The gavel strikes.
All right, John Harold Robinson. Court is calling 2024 CR 006935, State of Texas versus John Robison. Can I have parties announced for the record for the state?
George Sherman on behalf of Mr. Robison.
And are you Mr. Robison?
Yes, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Robinson, okay, is it Robinson or Robison?
Robison.
Robison?
Yes, ma'am.
All right. Because there's a misspelling on this, but all right.
I've heard it every way, so it's okay.
Thank you. Did you sign the document entitled Application for Community Supervision?
Yes, Your Honor.
Did you review that with your attorney and understand it?
Yes, Your
Did you review the true bill of indictment with your attorney?
Honor. Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, so attorneys, we're gonna go off the record. The whole trial court certification of defendant's rights to appeal, don't check any boxes. That's my call on whether or not you have a right to appeal. Does everyone understand?
Yes, Your
All
Honor.
right, we're back on the record. Defense, do you waive the reading of the indictment?
We do.
State, are you okay. State, are you proceeding on the indictment as presented? Mr. Robinson, did you review the document entitled Court Admonishments and Defendants Waivers with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
I believe so, yes, Your Honor.
All right, you're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Robinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. The state recommends community supervision, and there's to be ignition interlock for half the term of probation. Did you understand that to be the plea?
Yes, Your Honor.
State, is that the plea? Defense, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Yes, Your Honor.
Counsel, are there any such motions?
Yes.
What motions?
It was a motion to quash the indictment based upon an invalid prior, and you ruled against us after the hearing.
All right, thank you.
Mhm.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution. They're asking for 1 year Texas driver's license suspension and 10-day jail sanction. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers to exhibit.
No objection.
All right, did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. All right, with regards to the judgments that are in the stipulations, you're stipulating that you are the person who is listed in the judgment?
Yes, Your Honor.
Okay. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client?
Say again.
Anything you wish to say on behalf of your client?
Well, currently he's in handcuffs and, I guess this is for a bond violation. But should the court grant him probation, I presume he would be released today.
All right, so with regards to the length of probation, why should I give him 4 years?
Judge, it's a 2/3, so that was the reason that we came to that agreement. I understand the court's concern based on the stability of two evidence. However, I believe that the underlying term is sufficient to, he does not comply with terms of probation.
All right, are you employed?
Yes, ma'am.
What do you do?
A project manager for construction.
Do you have any children?
No, ma'am.
So what do you do in your spare time?
I work and then work on the house right now. Then I go and see my mother.
Okay. All right, they're asking for 10 days in the Bear County Jail. You can either do 10 days in the Bear County Jail, which would start today, or either you can do GPS, and that GPS would be for 20 days. And you would only be allowed to work. That's it. If you want to add to that, that you want to be allowed to see your mother, then your GPS is going to be for 45 days.
Okay, then I'll do 20 days. And my work is different areas of Austin, so it's kind of all over. Is that okay?
Yes.
But he lives in Hayes County?
I live in Hayes.
All right. He lives in Hayes County. All right. Are you asking to transfer?
Yes.
Yes.
All right, so he's gonna be doing it, counsel.
Yeah.
Here's the thing, your attorney can answer for you, but your attorney is not the one who's gonna be doing probation. You are. So do you want to stay in Bear County, or you want your probation transferred to Hayes County?
Stay in, so I'll go to Hayes County, please.
Okay. So there's gonna be a partial GPS for employment only for 20 days in lieu of the Bear County Jail. And that's due to the overcrowding at the jail and also different health concerns at the jail. There's going to be a $2,000 fine that'll be probated, regular reporting by Zoom or in person, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Transfer to Hayes County. TAP evaluation, out of custody, follow all recommendations. There's going to be 120 sober meetings in 120 days. DWI intervention, victim impact live, and DWI education. There's to be regular random UAs. Probation, is there any, I'm sorry, and 200 hours of community service restitution. If you would like, you can buy those hours at $7.25 per hour. Probation, is there anything else?
Okay.
Is there anything else you need from the court in order to be successful?
What's a TAP evaluation?
That's to see what type of drug dependency you may have. All right, any other questions?
No, Your Honor.
All right, and I'll ask that the warrant be recalled.
Also, one thing, I apologize, ma'am. So the outpatient that I'm currently doing for pretrial, is that still continuing?
You'll need to speak with probation because they're going to have you do a TAP evaluation and TAP will let me know.
Yes, ma'am.
Because all of your conditions were pretrial conditions. These are your current conditions. All right, any other questions?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the pretrial motions. You understand?
Yes, Your Honor.
All right, because this is a felon, yes? I wrote it in my notes, but I didn't say it. So it's 6 years in prison, suspended and probated for 4 years. All right. You have a limited right to appeal. That right to appeal is as it relates to the motions, pretrial motions that were ruled upon. But because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, you're one of those people who cannot drink alcohol. And when you're on probation, you're not allowed to drink alcohol. It doesn't matter if you're in your house. It doesn't matter if you're at a barbecue, whatever, it is not allowed. And if you're around people and you tell them that you're trying to be clean and sober and they're not helpful and they just tell you, just have a drink, those are not your friends. Because what I've learned is you got to change people, places, and things. It's hard to do. But if you don't do that, what's going to end up happening is you may pick up another DWI. You're looking at potentially 6 years in prison if you do on this case, or you may end up driving and killing someone. You understand?
Yes, Your
All right, good luck to you.
Honor. Thank you.
You're welcome.
The hearing begins with Judge Stephanie Boyd calling the case and confirming appearances on the record. The court verifies that discovery has been reviewed and that the defendant understands all documentation related to community supervision in the indictment. Judge Stephanie Boyd methodically walks the defendant through his rights, including the right to a jury trial, cross-examination of witnesses, and the right to remain silent. The defendant confirms he understands he is giving up those rights by entering his plea. Judge Stephanie Boyd clearly explains the seriousness of the charge, driving while intoxicated, third or more offense, classified as a third-degree felony. She outlines the punishment range, including the possibility of 2 to 10 years in prison and heavy fines. The defendant acknowledges understanding the risks and confirms his plea of no contest. After reviewing the stipulated evidence, Judge Stephanie Boyd formally finds sufficient evidence and declares the defendant guilty. The courtroom then shifts into sentencing. Defense counsel notes the defendant is already in custody due to a bond violation and raises questions about probation release. Judge Stephanie Boyd immediately focuses on accountability, questioning the length of probation and the defendant's personal circumstances. She asks about employment, family responsibilities, and daily routine, carefully evaluating whether the defendant can comply with supervision. The judge presents 2 strict options: serving 10 days in jail or accepting GPS supervision with limited movement. When the defendant selects GPS supervision, Judge Stephanie Boyd increases conditions if additional personal movement is requested, emphasizing that probation is not flexible convenience, it is structured accountability. She also confirms the transfer of probation supervision to another county. Judge Stephanie Boyd then delivers a detailed list of requirements: fines, reporting, proof of employment, treatment evaluations, sobriety meetings, education programs, random drug testing, community service, and restitution. The defendant is warned about firearm restrictions due to the felony conviction. In her closing remarks, Judge Stephanie Boyd delivers the most powerful moment of the hearing. She tells the defendant that alcohol is completely prohibited and stresses that continued drinking could lead to another DWI, 6 years in prison, or even killing someone. The courtroom grows tense as she emphasizes personal responsibility and long-term consequences. The hearing ends with the judge wishing the defendant luck, but making it clear that his future now depends entirely on compliance.